So what's to stop someone from just designing around your patent application, your patent? I get this question a lot, and there are really three things I wanted to touch on to help you get some clarity on that. The first one is fighting for broad claims. The second one, adequate disclosure. And the third one is keeping the family alive. So fighting for broad claims. The most important part of the patent is the claims. That's the coverage. And that's the part you may be spending the least amount of attention on. But that's where hopefully your patent attorney is spending the most attention, because the claims actually are the words written in patentees that describe the property that you will end up owning. So whatever claims in your granted patent, that is the coverage that you have. That's how most people think of it, is that's your coverage. So it's really easy to write claims that are very specific to the device that you walk into the office with. And this is where you want to be careful, because generally the lower the price you're quoted to get your patent, the narrower your claims are probably going to be, because it takes time and work with a patent attorney who cares and is actually fighting for broad claims to try to figure out what the broadest claims that you can have a chance of getting in light of the prior art. So I just wanted to point that out, that you want to make sure that you have someone fighting for broad claims for you. And that is going to cost a little more, but it's also what's going to give you the value in the patent that you want. You certainly don't want to have a patent that's granted that, or maybe you do, but most people don't want a patent that's granted that is just this one version of their product, and then anyone can just make a slight variation and get around it. So that's the way that you really are stopping those design arounds, is by having broad enough claims. And then adequate disclosure and keeping the family alive. The disclosure is the words. The claims are the numbers at the end, the numbered sections at the end. The rest of the words is what we call the patent disclosure. The purpose of the disclosure, there's a couple different purposes. One important function of it is that it gives you flexibility to file new claims or support claim amendments that you may need and want to capture new things that you've really kind of nailed down, or to give you fallback positions to get claims granted when an examiner is citing particular prior art that you need to get around or define around. And so having adequate disclosure gives you the support for those claims that you might really need. So it's really important. Another thing that's important is it actually, once your patent application is published, that disclosure creates you as prior art to anyone that might try to get a patent on something that you've disclosed in your application. So the more that you disclose, the more you are preventing someone else from patenting something that you invented. So, and that's global, by the way. And then keeping the family alive, you will have an opportunity before the patent grants to file. You can either just pay the issue fee and let it grant, or you can file continuation or continuation in part, which will then keep the family alive. As long as the patent family is alive, you can file future patent applications and build a patent portfolio that stems from one initial parent application that has early priority. This is again why you want that first one in particular to have a lot of disclosure to support all these future patent applications, because when you have that disclosure, it means that those future applications get the benefit of the early priority date, and that can be really useful. That makes you priority to a bunch of other people that have come after you. So just three ways that you can help make sure that your patent actually delivers for you and is effective, and preventing people from designing around. I hope that helps. Catherine Cavella, IP Works Law.